Welcome back, everyone, to Open Line. Happy to have with us Tim Takacs, elder law attorney, and he is really giving advice on how do you care for someone as they get older. It could be any one of us, or it could be a loved one, could be our parents, whatever the case may be. He can offer some advice, and he is joining us via Zoom there from his home. And all right, so Tim, we were talking about nursing homes. That's the one thing we talk about all the time, just the high cost, all of that. I'll ask about the cost in a moment. But what about, again, in this era of the coronavirus, how concerned are people about putting someone in a nursing home, and how concerned should they be, and how do they even, how do they check them out and that kind of thing?
Well, rightly or wrongly, they are concerned. We are not seeing people going into nursing homes. I can think of just two first meetings that I've had in the last couple of weeks where we had actually three that I can think of where, one of the children has either been laid off or had their hours reduced or voluntarily quit their job, so that they could take care, of their parent. Needless to say, that's not something that and certainly 6 months ago, they never expected to be doing that. But maybe either voluntarily or involuntarily, they realized that, okay, I might as well do something if my employer is either cutting my hours or I'm on unemployment. So I'll go I'll take care of my mom or my dad. So we're seeing more and more of that. And of course they're faced with the same challenges that caregivers always, are faced with. But at the same time, additional challenges arise for them because one is that to get paid help in the home may be difficult. Right. So getting non-medical in-home care from an agency, the assumption I'm making here perhaps is that maybe they're struggling. They're not being able to be able to see people in their homes. And of course, if you've got a child that's that's basically living with mom, taking care of mom because the child is unemployed now, that's less work for a non-medical in-home agency to do. So and then of course you always have to think about what's the backup plan because children get sick, all sorts of things. So are they really thinking about moving, say mom has to do respite in an assisted living or whatever, are they really going to do that? Will the residential care facility actually accept someone as a resident? Without, particularly if there's been obviously problems with the facility, if there's an outbreak or whatever, maybe they're going to be shut down. So there's a lot of things that have changed about certainly about people's options, and they're not really thinking about nursing home care. In fact, and of course, all of our clients have said, well, I don't want to go to a nursing home, but
right.
But we're really
now I would think more
people.
than ever, because I think it's like 40% of the deaths have come in nursing homes.
I think something like that.
So it would be very scary to be thinking about putting a loved one right now in a nursing home when you hear that kind of data.
Yes, exactly. Right. And then you have some facilities that essentially are going to go, well, it may be difficult to get in anyway. And certainly if the facility is on lockdown because maybe residents or staff have tested positive, maybe they're going to be prohibited, or very strict limitations, on admissions.
And I hadn't even thought about the in-home health care, but it's absolutely right. I mean, you said you are very responsible with, you and the people in your office are responsible, where you go and that kind of thing. When you are inviting someone into your home with one of these home health care companies, you are really counting on the fact that the person coming into your home has taken all appropriate steps, because that is an opportunity for that person to make others around them sick. I mean, you have to be really careful.
Absolutely. Right, because you don't know, okay, maybe it's a 20-something or a 50-something or who knows how old that they are, but you can't unless they deliberately, those employees deliberately decide to basically essentially quarantine themselves, so almost like 24/7, because, okay, going downtown, going to a restaurant, going to the grocery store, I mean, you may wear a mask or they may wear a mask, but if somebody doesn't next to them, I mean, I think we all are recognizing now is that the virus is an air. It's primarily transmitted by air. And all the more reason why having masks. Me having a mask doesn't help me, but it helps you. Right. That's the whole point.
Yeah. All right, we have a few calls. Let's go to the phones now. Let's go to Carnelita.
Great.
Hello, Carnelita?
Yes, hi.
Hi, go right ahead. What's on your mind?
Okay, I was calling for some information. My mom is the last of 12 siblings, and back in that time, they didn't do wills. She was left with a lot of land, and now I just need some information on what she needs to do to secure it. She's paying the taxes on it, but the other family members, descendants, her nieces and nephews, are all wanting her to sell it or either give them a piece of it or cut the trees down on it and give them some money out of it. What do we need to do to protect her? Since she is like the caregiver or the caretaker of the land at this time.
You're saying she's the only surviving, I guess, descendant of the parents? Yes. So, yes. And these other cousins, they're not.
She's now the owner.
And she's now the owner. Is that right? She's the sole owner of that land.
Well, not on. Well, on as far as paying the taxes. Yeah, she pays the taxes every year.
All right. Well, Tim,
so what? Her sole owner?
Yeah.
If she pays the taxes,
I guess. Well, what I'm thinking is, I think, Ben, like your question is a good one, which is she's the last surviving sibling, and I mean, my assumption would be is that when her parents died, they left that property to their children, whether that's 5 children or 10 or however many. So it could be nieces and nephews can claim ownership. So in other words, she's the last of that generation. And the younger generation, younger than her, maybe her nieces and nephews, could be owners of that property. So I think the first thing to do would be is to kind of sort out who the owners are and see what interest that she has. In other words, what percentage interest that she has. Merely paying the taxes doesn't make you the owner. It may make you, the co-owners may be obligated to you, for paying the taxes. But I think the first thing to do would be to sort out her ownership, and then she needs to make a plan for, what does she want to do with that property, or what does she want to do with her ownership. Let's assume that she is a sole owner. We don't necessarily want her to give that property away, because why would she do that? Unless she, because my assumption is that, maybe she needs that property to help take care of herself. Maybe she sells it. She puts the money in the bank. If she's an older person, if she is in a position to be able to make gifts, then that's okay. But I mean, that's kind of like part of the estate planning piece that we sort of have to put together for her, is to say, okay, what is it? What are your goals here? What are you worried about? What do you see your future being? And needless to say, it all gets back down to is, does she have personal care needs, that she ultimately needs to start planning for?
It sounds to me like, based on talking to you for a long time, Tim, you would be able to look on a will and see, okay, did the parents give it to the kids, like you said? Did the parents give it directly to that one sibling? Are the nieces and nephews on it? Now, maybe they didn't have a will.
Right.
Let's say the parents didn't have a will and they died. If that's the case, wouldn't her children be next in line? Or let's go under the assumption that there was no will and this land is out there.
There was no will. Right. If there was no will, then at the death of the surviving parent, then the property then goes by law to the surviving parent's children. And if a child had predeceased, and that child had children, then it would go to the grandchildren, and right on down the line. So that's the way that works.
Yeah. So it could be complicated.
The law does. It could be complicated. Sorting out who owns what.
Okay. All right. That's interesting. So my last question, because I'm fascinated by it. So the parents die. They had 12 kids, let's say. One of those 12 is still alive, but a couple of those other kids that died, they had kids themselves. Would those kids that they had, would they have lost their right to the land when the parents died? Or you're saying even though the parents died,
no,
it passed on to those other kids?
It passed on, yeah, exactly.
Okay. Very.
Right. And that's why you have if there's a will, then, that makes a different disposition. But ultimately, if a child predeceases the parent and that child has children, then the grandchildren inherit.
So there would be some claim there on the part. Okay.
Yes, there would be.
Well, Carnalita, I hope that helps. If there's a will, you need to find that will. If not, then you need to figure out some.
I would just suggest to Carnalita is, we'll have our contact information up. You can. It may be out of our geographic area, but Ben, as I've always said, is that we want people to call us, and we can talk to them and see if we can help them. We will refer them to somebody that we feel like that can help them.
That's right. Okay.
At the very least, we'll do that.
All right. Let's go to Michael now. Hello, Michael.
Yes, hello, gentlemen. Good evening. I am widowed. I have a daughter and a son. I do have a will, but I do not have a durable power of attorney. My dilemma is, should I give durable power of attorney to both my son and my daughter, or if not, why? And what should, when I'm considering the two, and I have to choose one over the other, what do I really need to look for? Thank you.
Wow. Okay.
Well, that's a great question, because here's what we see all the time, not all the time, but we have, and this is, I guess, the benefit of, frankly, our experience doing these documents day to day. The purpose for having a durable power of attorney or a healthcare power of attorney, is to convince some unrelated third party that to rely on that document. I've had clients come into my office that have documents from other lawyers that will say something like, I name my son John and my daughter Nancy, and or, they can each act jointly and or separately, and it's kind of like, well, is it and or? And ultimately, when one of those children goes to the bank and the bank looks at that document and says, your brother needs to be here because I can't figure out who's in charge. Because I've seen him with 4 or 5 people named on them, and they're all say like and or. Well, basically, then you have decision making by committee. So, in virtually all of the documents that we draft and our clients, that's our job, is not just necessarily to give our clients what they want, but to give them what they need. It's not about disrespecting any child because maybe either by proximity or age or whatever it is. the first thing that you want to do is make sure that you're going to name the right person, whoever that person is, that will carry out what your wishes are. And it doesn't matter whether it's the child that you're living with or one, maybe across town, or whatever the age is. Now, that doesn't mean you name only that child or other, what you do is you say, in our documents, we say, I name my daughter, Nancy, as my attorney in fact, and I name, if she is unable or unwilling to serve, then I name my son, John, to be my attorney in fact. So you have a clear line of succession. And we use the term unable or unwilling to serve because we feel like that kind of covers the waterfront. Unable means, could be is that, well, Nancy's in a hospital right now and she can't be here, but John is available temporarily. Nancy is temporarily unavailable, so John can step in, and he can act for you, as a successor, or if basically Nancy says, well, I don't want to be this anymore because this lawyer told me on open line that, being a power of attorney for somebody is not involuntary servitude. So I ain't going to do this anymore. So I'm going to resign. And if Nancy resigns, then John steps in. It's basically about having a clear line of authority in that document.
And that makes sense. And then, but it sounds like what Michael might also be asking is, he has maybe two kids. He loves them both equally. They're both equally responsible. All those things. How do you pick? I mean, you're saying you shouldn't put both. That's not good. That's not right. That doesn't make for a good document. Good things to happen. You got to pick one.
Yes. Right. Pick one, and then have the other one. Because as a practical matter, what we see is that, particularly in healthcare decision making, if the family gets along, and it's like, look, it could be my son or daughter, because I know both of them would be capable of doing it. You name one person, number one, whether it's the son or the daughter. You have conversations with both of them as to what you want. And let's say you named your daughter as the primary healthcare agent, and the son is the backup healthcare agent. They're going to consult with one another anyway.
Right.
But the fact of the matter is that, when a decision has to be made, the healthcare provider wants to hear it from one voice. And that's the person that you've named first.
Oh, that makes sense.
And a lot of that then becomes, Michael, is education, educating your children, and say, okay, here's the way I've decided to do it. Okay, child number one is first, child number two is second, or however way you do this. And here's the reason for my decision. Because I expect both of you to cooperate, and the whole point is to eliminate any obstacles or any barriers, that some third party like a bank or a financial institution is going to say, oh, wait a minute, we need both of you here in this office for us to do anything. That's why, we really recommend that we strongly recommend that you do it that way.
That makes sense. And I like that. I expect you both to cooperate. That's an important thing that kids need to hear, I guess.
Yeah.
All right, we are going to take a break. If you want to call in, there's the number at the bottom of the screen. There it is, right there. 615-737-PLUS, 615-737-7587. Take a break. Be back right after this.